there. In today's video, I'm going to tell you how to lose your kids. Bet you didn't expect me to start with that. As a lawyer who regularly represents dads in contested divorce trials, I have some very straightforward advice for parents going through divorce. From the outset, it's important for mothers and fathers to recognize that married parents of minor children start out with joint custody rights. This means both parents have equal rights to their children. Custody is not parenting time. In a world where many households contain two working parents, and many fathers have an active role in raising their children, the presumption that mothers will automatically get custody and primary parenting sometimes no longer exists. Parenting law, the way it's written, is gender neutral. And this means that the facts of a given case are applied to the governing law, and a court then determines if it's in the best interest of the child to primarily live with dad and not mom. Now here's 7 of the most common pitfalls of people going through parenting disputes. If you want to lose your case, here's the way to do it. If you're a parent and want to win, steer clear of these things. Not being the primary caretaker. In most households, one parent is most responsible for caring for children's basic needs, the so-called primary parent. The parent who's most involved with the children's daily lives usually has the edge here. And sometimes it's age-related, whereas a baby or a toddler may need mom more than a 7 to 10-year-old who's more involved in what dad wants to do. But if you don't put your time in helping your kids with homework, feeding, bathing, reading to them, taking them to the bus stop, taking them for school, or taking them right to school, or picking them up, you're at a disadvantage in a parenting case. There's no better way to lose on parenting than to demonstrate to a judge that you simply weren't involved in raising your child. Number 2, not being active in your client's not being active in your child's schedule and activities. Do you know the names of your child's teachers? Have you ever supervised your child at a play date or taken your child to the doctor when they're sick? Do you regularly attend school conferences with the teacher? And how about school events? If the answer to these is no, then it's an indication that someone else, probably the other parent, is the primary parent, not you. If you're not addressing alcohol, drugs, or other parental fitness issues, a parent who even casually partakes in alcohol and or drugs will have a problem winning shared or primary parenting. Doesn't matter if it's legal, it's the use of it. And is it going to impair your ability to parent your child full time? Most judges will take allegations of substance abuse seriously, and these allegations will be investigated thoroughly via random testing at times, psychological evaluations, which can cost up to $25,000, and interviews. If you have an issue with substance abuse, then seek treatment for it immediately. If you are a perpetrator of domestic violence or abuse, which often goes hand in hand with alcohol and drug use, this is also pretty much guarantees you'll lose. So you got to keep yourself clean. What's more important? Drinking, drugs, or your kids? If it's not your kids, then don't go for primary parenting. Number 4, leaving a paper trail that's going to hang you in court. Thanks to new technology, virtually every hearing features a submission of evidence that can be used to portray another parent in a very damaging light. Sometimes the evidence can make or break the case. The evidence can include text messages, photos, or negative emails. Also potentially harmful are video and voicemail recordings. If you are prone to sending impulsive emails and texts, ranting and raving at the other parent or third parties or your own child, you're at a risk of losing. Count to 10. Put away that text or that email for 3 days before you send it. See if you still want to send it 3 days later. 5, disparaging the other parent. Judges tend to look favorably upon a parent who demonstrates that he or she supports the child's relationship with the other parent. A parent who's constantly denigrating the other parent, leaking anger, and negatively influencing the child's relationship with the non-custodial parent will be reprimanded. In extreme cases, there will be allegations of parental alienation and interference with parenting time. Many judges will consider a change of parenting if a parent does this. There is case law which shows where one parent who was the primary parent lost complete access to the child for months at a time because of parental alienation. It took a long time, a lot of battles in court, a lot of experts, but it is possible. Bottom line, if you want to show the judge that you'll promote the best interests of your child, then you need to show that you value the child's relationship with your ex and take steps to encourage that relationship. Of course, when you're going through adversarial court proceedings with someone you don't like very much anymore, it can be very hard to put those feelings aside for the sake of your child. But that's exactly what you need to do if you want to prevail in your case. Your child's relationship with your former spouse is not your relationship with your former spouse. You need to recognize that very quickly upon separation. Two different relationships, don't mix them up. Another way to lose your kids, show a lack of control. It's critical to consistently act with good judgment and self-control if you want to win. A parent who regularly loses control and cannot control his or her anger is at a disadvantage. I have handled cases where a litigant will lose control right in the courtroom, right in front of the judge. An angry outburst in court will be remembered. Similarly, a parent who acts out in front of the child's lawyer, psychologist, teachers, neighbors, etc., will find him or herself confronted with a lot of negative testimony and evidence at trial. This is where the voicemails and emails also come into play. If you're serious about winning, you must exhibit self-control and put your child's needs first. Going through a divorce is a difficult, emotional process. A custody case raises the stakes considerably. If necessary, seek counseling to get your anger under control, alcohol and drug use under control if necessary. At the very least, taking this step will likely lead to improved relationships with your ex, other third parties, family members, and most importantly, with your child. Number 7, how to lose your kids, failing to follow your lawyer's advice. Going through a divorce and a parenting proceeding is one of the most stressful experiences there is. Whether you're seeking primary parenting of your children, joint decision making, or a customized parenting plan, your goal should be to survive the process while protecting your rights to your most valuable asset, your children. Do what you're told and do it well. It's critical that you seek out the advice of an experienced family law lawyer who has handled contested parenting trials, not a lawyer who did the closing on your house or a lawyer who charges the lowest retainer to do an uncontested divorce. With an experienced advocate on your side, you can avoid making mistakes outlined that I've gone through, and you can be successful in the battle to have your kids in your life.